Well, hello, everyone. Welcome to this week's issue of Monday Morning Meeting. And this is where Sam and I, by the way, I'm Wilson Cole, Adams, Evans, and Ross, president of Adams, Evans, Ross. And I'm here with our in-house attorney, Samantha Cole, and my lovely daughter. How are you doing, Sam?
Doing good. Can't complain.
This is the episode, Sam and I meet every Monday. We have a full staff meeting with everybody, and then we have our own staff meeting between she and I, and to discuss different issues that kind of come through the courts over on her side of the fence and with our clients. And we will take your suggestions on topics. And then through the week, we just run into stuff that it's like, wow, that was a pain in the butt. What can we do to help our clients not repeat that mistake, or another client not repeat that mistake? And this subject is going to cover something, and I'm going to have Sam give you kind of the legal aspect of it. And then I'm going to kind of come back from it. A lot of people say, well, Wilson, are you an attorney? And I always say, no, I'm just an honest business guy. So we're going to give you the legal perspective, but then I'm going to kind of give you from a practical standpoint what that means and how costly this particular subject can be for your business. And like I said, we can give you tons and tons and tons of collection advice. We don't offer legal advice because even though Sam's an attorney, we're not a law firm. But I can tell you this subject we're going to talk about, if an attorney ever tells you to put it in there, from a business standpoint, I would bring up these points and see what they say. But I can tell you from a collection standpoint, when we see this one subject in a contract, it is literally the kiss of death. So Samantha, what are we going to talk about today?
So arbitration and mediation clauses. Everybody thinks they're great because at the end of the day, you see them if you actually read through the terms and conditions of, your email contracts or, your iTunes updates, which I do say that is the number one lie in the world is I have read the terms and conditions and I agree, because nobody's actually read them. But everybody sees an arbitration clause and that must mean that's the best way to handle it, or a mediation clause. That's great. And why they're put in there is because then the responsibility isn't on the party that's been wronged. It's now on both parties to split the cost.
Yes.
So mediation is where you're brought in, and because there is a difference between mediation and arbitration, and each state has different rules. And so I won't even go into the breakdown of that because that would lead us forever and everybody would be asleep in about 5 minutes. But you have where both of them, you bring both parties in, you usually have a representative, and again, depending on the distinctions each state has, from the court, or you have an attorney that is acting as the mediator. Each side has their attorneys, and you have a little mini negotiating session or a long negotiating session to figure out the problems and come to an agreement. The issue is it's going to run you about $10,000 to $15,000 between paying your attorney and paying the cost of the conference room, the court reporter, all of that. And beyond that, if you spend 8 hours in that conference room and don't come to an agreement, you still have to file suit. So now...
And it's also with mediation, it's not, I'm sure they can use it to help support the case, but with mediation, it's non-binding.
Right. And you can have binding arbitration, but those usually require you go through mediation first.
Okay.
So it can be a long time waste of money, waste of, resources, waste of time. There are situations that I will highly recommend mediation first. However, that's divorce with a child involved. Here, we're not running into that situation. I think that you have to look at it of, you're going to have to start spending costs, and you're like, well, with you guys, there isn't, a cost unless it's collected. Except if it is mediation, our contingency, we can run it through collections, but if it has to be forwarded out, none of our contingent attorneys will touch it, because you can't file suit if arbitration hasn't gone through, because that'll be the first defense. The other side, you file suit and they're like, well, there's an arbitration clause or there's a mediation clause. And now you have to start over. And the attorney the amount of work that goes into it. The attorney is going to go, I've got to charge my hourly rate of $350 an hour.
And if you're in the Midwest or the South, it's $500 or $600 if you're in California or up in the Northeast.
Exactly. And so it starts churning that bill, and there's nothing you can do until you've spent the money and gone through mediation. And I saw one the other week that you had to go through both mediation and arbitration. So at that point, you're spending more in the legal fees to fight this than the actual cost of the placement.
Okay. So that's the legal overview from a business standpoint. And Sam, correct me if I'm wrong, but basically the way I've always viewed arbitration is really great if you have two people that are honest, full of integrity, and they want to find a way to resolve it, because everybody knows you can have a dispute and neither one are really right or wrong. It's just looking at it from a different angle. Okay. So you're trusting the fact that you're dealing with a really good guy that has the ability or the willingness to pay if they lose. The problem with whether they're trying to stiff you on a staffing bill or if it's a backdoor hire, either one, they're in survival mode, or B, they don't have the integrity to pay you. So that runs into a problem there. From a mediation standpoint, whenever we are dealing with a debtor's attorney, I can tell you when they say, well, there's an arbitration clause in your client's contract, you can hear the smirk over the phone because they know what that client has done to themselves, and it just got much, much more expensive. And you can go through mediation and arbitration, and then the debtor still doesn't pay. Now, that may help your defense if you go into the courtroom, but the courts don't enforce mediation or arbitration without having to sue, at least in the cases that I've seen on collection.
Unless it's binding, and that gets into more expense and things like that. But
So from a logistical standpoint, our forwarding attorneys have been with us. Some of them have been with us, that have been with me as our forwarding attorneys longer than Sam has been Sam. And so they've been here a very long time, but they're also running businesses. And so the reason that we can get it done on a contingency basis is because of the sheer volume that we send to these attorneys, but also they say, well, we can put in XYZ hours and get XYZ money back. With arbitration and mediation, it doesn't work that way. Now, don't confuse the mediation clause with after you sue them. In some courts, Texas is, and I think New York is one, where they will force mediation. And it's pretty much forced mediation is where they have you go in about 3 months, 2 months, whatever, before a court date and make everybody sit down to see if it can get resolved. Typically, there is no additional charge for that, or it's $100. It's $200. I mean, it's very small. Typically, it's part of the suit process, and the logic of the courts is to force everybody to sit down so they don't have to get the judge involved. So don't confuse if you ever sue somebody and then we call you and say, hey, there's a mediation meeting. Don't ever say, well, I don't have mediation in my contract. That is just something that the courts will do to try to clear their calendar. It's the same thing, but the cost is carried by the courts, not by you. With the way that we like to see it is if you don't have an arbitration clause, if you don't have a mediation clause, we can send it straight out to our forwarding attorneys. It costs your court costs $650, $800 or $700, depending on the venue, and to get court or to get suit filed. And then it runs through that process, and your attorney is handling it on the collection matter on an hour or on a contingency basis, but you flip the tables to where the debtor's attorney is charging them by the hour to defend it. So you've got a strategic advantage if the other guy is the one that's having to write the check. And I can tell you, no matter, I've done this 27 years, no matter how long or how venomous or how battle ready that debtor is, once they start cutting checks to attorneys, they start trying to look at a way to resolve it. It becomes a risk and reward. So Samantha, instead of the arbitration clause, I mean, I know that you have your resource vault, which is some of the wording and contracts that you like to see. And if you email Samantha at aercollections.com, she'll send you access to it. It's not legal advice. It's just kind of best practices, but there's a copy of the contract that she really likes. But so if they see a mediation or an arbitration clause, now what you're saying is, from a collection standpoint, you need to get rid of the arbitration or mediation clause. What if you're dealing with a debtor and they want you to sign their contracts and that's in there? What do you do?
I mean, that gets into if you're negotiating with them and say, maybe, and again, it's kind of risk and reward of well, I'm not crazy about an arbitration clause. How about you could put in each side carries their own expenses clause?
Okay, good.
Which then, again, risk and reward, you may not be able to sue for attorney's fees if you have to sue for it.
No.
But you're also saving the risk of having to, because they're putting it in there. If you're dealing with, a big, Fortune 500 large corporation, if it's in there, they're doing it because they know that, because also mediation and arbitration requires everything split down the middle on costs.
Yes.
So they're putting it in there knowing that you've now got to pay $7,000, $8,000, because I think some of the figures I've seen recently is it's around $15,000 for the entire cost of arbitration. Some of those figures include when you have to hire your own attorney and things like that. But they're putting it in there knowing that you're going to have to deal with those costs. So if you go, everybody covers their own costs. Okay, if you have to litigate, then, you're going to be out you can't ask for attorney's fees, but it allows to at least get that arbitration out, and it'll be cheaper. In a lot of cases, having to pay the 35% will be cheaper than what you'd have to spend for arbitration.
Okay. So basically, we probably have spent 15 minutes saying this. Arbitration clauses, from a collection standpoint, in my opinion, absolutely suck on being able to find a contingency-based attorney through there, and also it slows it down in the collection process, because if that debtor's attorney knows that there's an arbitration clause, he knows that it just took something that was going to be very one-sided. When you sue his client now bears all the costs, to where it evened it out, to where now our clients are going to have to match dollar for dollar. So arbitration clauses from a collection standpoint, not good. Agreements without arbitration or mediation clauses are typically much better from a collection standpoint. Yep. So Sam, before we jump off into our other subjects and you and I wrap up this podcast, is there anything that you want to leave the audience with as a departing thought, or did we just cover it?
I think we covered it.
Okay. Thank you, guys. Next week, we've got a really exciting topic that we're going to hold in surprise for you. If you, hopefully you don't need us on collections, but if you do, certainly reach out to us, 800-452-5287. I'm at extension 6578. With Samantha, if you want a copy of the best practices agreement, her resource vault, email Samantha at aercollections.com, put in the subject line, resource vault, and Samantha will get it over to you typically within about 48 hours of it getting over there. Thank you, guys. Have a good week, and thanks, Sam, for joining me.